Thanks again for joining us. As I just said, today we're going to talk about Michigan's surprise medical billing law. We'll be covering both what it means to providers and health plans. Again, so here's our agenda. We'll start off by discussing some of the definitions, and then we'll move on to the way I've kind of looked at this bill and tried to understand it. I'm dividing it into, what happens with emergency patients and what happens with non-emergency patients. After that, we'll talk about disclosure requirements, dispute resolution requirements, and what health plans need to know. I will say that I apologize in advance if you hear a few more ums or I don't knows kind of from me. This plan is sometimes, or this bill can sometimes be a little bit difficult to follow, but we spent a lot of time diving in, and I think you'll get a lot out of our presentation today. All right, starting off with important definitions. The first big one deals with what is defined as a health benefit plan. Some of the elements include, it's an expense incurred plan, including an HMO, self-funded plan established or maintained by state or local government. So those are the health benefit plans that fall under the definition of health benefit plan for this law. In other words, if an individual has one of these qualifying plans, then the surprise medical billing rules will apply to it. It does not include self-funded plans, which are subject to ERISA. Tripp, you can kind of weigh in here, provide some clarification.
I was going to jump in right here. So this has been a source of a lot of confusion over the past months about whether this bill or this Michigan law would apply to self-funded plans that are subject to ERISA. So those are self-funded plans sponsored generally by private employers. Self-funded plans that are not subject to ERISA are those sponsored by governmental entities or church employers. We know that governmental employers, at least governments in Michigan, their self-funded plans are subject. I think the jury is still out on the church plans, but I think it is, for several different reasons, which I'll kind of quick cover. I think it's pretty clear that self-funded plans subject to ERISA are excluded. So first of all, the statute, if you actually have any interest in getting into it, really goes out of its way to separately define and include self-funded plans that are established by the state of Michigan or a local government in Michigan. And I think, Tim, since this is not only a legal update, but we're addressing medical subjects here, be a great time for a little Latin lesson. What do you think?
Yeah, I think that's seems appropriate. I'm sure everyone will love that.
Tim and I are a little bit of nerds on this. So there's actually a statutory rule of construction that is called expressio unius est exclusio alterius, which basically means in English that by the inclusion of one thing necessarily means to exclude the other. And how you apply that here is the fact that the bill kind of actually specifically includes self-funded plans established by the state of Michigan or a local government in Michigan is to therefore necessarily exclude any other self-funded plans. Also, the Department of Insurance and Financial Services, which is going to have a role in administering the provisions under this law, issued a regulatory impact statement and cost-benefit analysis when it issued some administrative rules under the law. And this RIS statement or cost-benefit analysis basically had to answer a question about whether there's any overlap between federal and the state law. And the answer was no. And it said because the state law is going to govern state-regulated plans where, and this is a little bit of a preview here, the new federal No Surprises Act is going to govern self-funded health plans. So again, it appears that DIF's position is that this law does not apply to self-funded ERISA plans. And then, of course, you've always got that even if the state took the position that this law did apply, I think it's probably I would be pretty confident that it would be challenged on an ERISA preemption basis, and that would probably be successful. Now, for those of you that are on the webinar today and are with an organization that has a self-funded ERISA plan, don't feel too left out, because even though this law does not apply to you, part of the Consolidated Appropriations Act of 2021, which was signed by then President Trump on December 27, 2020, contains this No Surprises Act at the federal level. And that law, which will take effect for plan years beginning on or after January 1, 2022, is going to impact self-funded ERISA plans. And we do plan on doing webinars on that in the future. But right now, all we have to go on is the legislation. The Departments of Labor, HHS, and IRS were instructed to issue additional regulations by July of this year. So for those calendar year self-funded plans, this is going to be an issue for you. At least the concept of no surprises and certain payment requirements is going to become an issue for you in 2022 unless that law is otherwise delayed. Tim, I'll kick it back to you.
Thank you. Yeah, thank you, Tripp. I mean, it sort of sounded like you made up that term or it was some sort of like Harry Potter spell, but I assure people that that is an actual legal term that that we occasionally use when interpreting statutes. So, you know, the other definition.
If they don't learn anything else here today, Tim, at least they've learned a little bit of Latin.
That's very true. And so, as Tripp said, I mean, this is going to be, he mentioned this federal plan, you know, that's going to add another layer of confusion possibly to how providers are going to comply with these laws. There might be a separate dispute resolution process for ERISA plans. Providers are going to probably need to work with, you know, if you're at a hospital, with the hospitals, or work with patients to do your best to identify whether someone has an ERISA, a self-funded plan that's going to be governed by ERISA and the federal rules versus a non-self-funded plan that's going to be covered by these state surprise rules. So again, like Tripp said, as those final regs come out in July is the current plan, but government often delays those things, we'll definitely circle back around and provide some more education for clients. The next definition.
Tim, just to make one more comment on that. You know, I think, because I get this question a lot, you know, and again, I definitely think this is going to be, you know, the intermingling of the state law and the federal law is going to be a bigger issue for providers than it is patients. But some of you may have a nagging question like, well, how am I going to know whether an individual is covered under a self-funded ERISA plan or a fully insured plan that's subject to this law? And the answer is at this point, there's really no good way to figure that out. I mean, you can obviously ask the patient or ask the participant, but there's a good chance they may not know either, right? You know, if I work for an employer that uses an insurance company that also, you know, has fully insured plans out on the market to administer my self-funded plan, you know, I may think that, you know, my plan is fully insured because my health insurance card, you know, looks exactly like the same as someone has a fully insured plan. Now, maybe there's a small designation. You know, I think mine, for example, says SF in very small letters on the back corner. But I think the reality is there's no easy way, at least right now, to identify when a participant is covered by a self-funded plan versus a fully insured plan. And therefore, which one of the laws and which one of the dispute resolution processes is going to apply. With that, right. I think then we can move on, so we don't spend our whole half hour or hour on this one issue.
I should say before we panic everybody too much, you know, when it comes to the obligation to figure out if a plan is self-funded or not, you know, you're going to. This only applies if it's a non-participating plan. If you're participating with whatever insurer the patient has, then, you know, you don't have to worry about this issue or really any of the issues we're talking about. But I just want to make sure before, you know, if anyone kind of tunes in and isn't overly familiar with the law, that they understand that that's what that's the scope of this. So as Tripp said, I kind of want to move it along here. Emergency patients, you know, for those who, you know, I'm sure we have some emergency physicians or groups on the line, they'll recognize this definition from EMTALA, which is sort of a patient anti-dumping statute that requires hospitals to treat people that show up with emergency conditions. But it's important because non-emergency patients and non-emergency care is treated differently than emergency patients. So it's going to be important to identify, hey, is this an emergency patient or is this not? And so an emergency patient is a condition that places health in serious jeopardy, serious impairment of bodily function, or serious dysfunction of a body organ. At least under EMTALA, a woman in labor has an emergency medical condition, and I assume would be considered an emergency patient if you're not able to transfer her. These terminology, it'll be interesting to see if there's disputes over whether someone is an emergency patient or not, because it's sort of an awkward application of the EMTALA concepts. But non-emergency patient is then sort of the opposite, not in imminent danger of loss of life or significant health impairment. Excuse me. All right, so as I mentioned, I kind of view this law in two separate ways. I divide it between emergency patients and non-emergency patients. For those who have looked at the actual statute, yeah.
Did you skip a slide of important definitions?
Did I? I might have. Oh, there we go. Provider. Thanks, Tripp. Provider is someone who's licensed, again, physician, PAs, NPs. The Article 15 of the Michigan Public Health Code has a whole bunch of health professions. But again, psychologists, therapists, all those, there'll be a wide number. Basically, anybody who's licensed to provide medical services in Michigan will be have to comply with this law. Health facility, again, includes pretty typical hospitals, freestanding outpatient surgical centers, ASCs or ambulatory surgery centers, skilled nursing. Physician's offices is included as well, which is an odd inclusion, but doesn't really have too much of an impact, I don't think, on our clients. Again, participating provider or facility, if you're under contract, if you have an agreement with, Priority, Blue Cross, United, HAP, those groups, and you're agreeing to provide services, and then non-participating is obviously someone who, for a provider who's out of contract. And again, in talking with clients who've had questions about this, it's not a huge percentage of what you guys do on a daily basis is, encountering out of patient or out of network patients, but it's enough there, and this also does impact sort of the leverage that insurers might have, payers might have over our providers. So it's important to make sure you know how to comply with these. So for emergency patients, the payment is capped if provided by a non-participating provider. So again, when someone shows up at the hospital, or, most likely you're going to encounter an emergency patient in the hospital. I suppose it could happen like in an urgent care center, possibly. You don't participate with their insurer. You provide emergency services to them. The services are covered by the plan and the facility, and provided at a participating health facility, or actually it's also a non-participating health facility. So the bottom line is, if you're providing emergency care, your fees are going to be capped. The second scenario, which is kind of an expansion on that, is if it's provided at a participating facility. So you're a non-participating provider providing care at a participating facility to an emergency patient within 72 hours of them receiving services in the emergency room. So the patient comes in, they're an emergency patient, they are admitted to the hospital. The services provided within 72 hours by non-participating providers are going to be capped. For emergency patients, there's no disclosure requirement. And again, the payment is capped, as I said, for the out-of-network patient. And the cap is the greater of the carrier's median amount for the region and specialty, or 150% of Medicare. So whichever of those two is greater. And we'll get in a little bit how, if you disagree with the amount that you receive, that's median amount or 150% of Medicare, if you disagree, then there is a way to dispute that. Again, so as I mentioned, the cap also applies to services by a non-participating provider within 72 hours. So, hospitalists, this might impact you. Neonatology groups, it might impact them as well. I guess slightly on the upside is carriers must pay within 60 days of receiving the claim. Providers, if you're a non-participating provider, you can only collect the in-network co-insurance, co-payment, or deductible amount. So, there's no limitations, interestingly, or restrictions for non-participating facilities. The only limitation applies to non-participating providers. There's no indication that surprise sort of facility fees are prohibited. But again, as we've kind of covered here, the surprise, professional fees for out-of-network non-participating providers are going to be capped at that median amount or the 150% of Medicare. All right, moving off of the emergency patients and on to non-emergency patients. For those patients, the payment is capped if provided by a non-participating provider. If it's provided to a non-emergency patient, it's covered by the non-emergency patient's health plan. It's provided at a participating health facility, and the non-emergency patient does not have the ability to choose a participating provider, or the patient has not been given the disclosure. So you can balance bill patients if if all of these are not, if you provide a disclosure and each of these are not met. So the situation where you would be, if you're a non-emergency provider, you provide the disclosure as you're required to, you still can't balance bill the patient if the patient does not have the ability to choose a participating provider. So that's the one limitation. Exactly what does that mean? I don't know. If the patient receives the disclosure and there's an exclusive provider for that service within a hospital, then do they have the ability to choose a participating provider? Again, I mean, my answer to that would be probably not, but it'll be interesting to see how insurers try to enforce that provision. How are they going to know if a patient was provided the ability to choose someone else? Is handing the disclosure to the patient, giving them an opportunity, is more required of that? I think there's some uncertainty as to exactly how that particular scenario will play out. If you're providing it in a non-participating facility, you are free to bill the patient. Or again, if they have the chance to choose a different provider and you provide them the disclosure, you can still balance bill those patients. Again, as we said before, this provision addressing non-emergency care does not have, it only applies to providers. There's no participating facilities aren't required to provide a disclosure. Their fees, non-participating facilities fees are not capped. There's no prohibition on them balance billing a patient for the facility fees. And for those who, the health plans, you probably are familiar with the concept, but often, like say in an ASC, an ambulatory surgery center, there's a facility fee and there are professional fees related to any given procedure. All right, the disclosure obligations. So when do you have to provide the disclosure? We'll get to the content of the disclosure, although the bill lays that out pretty precisely. You have the disclosure must be provided 14 days before providing services. If it's in the health facility, you can provide it at the time of first contact, including during one of the following: a pre-surgical consultation, a scheduling or intake call, a pre-operative review. Now, the exception to this idea of providing it at the time of someone's first contact is it cannot be provided at the time a non-emergency patient is admitted or at the time of surgery or other procedure. So obviously there are certain types of providers like anesthesia who, anesthesia providers don't have offices where they're seeing patients. They're not the ones who are scheduling and meeting with people. to schedule a surgery. Generally, if not always, the first time they see a patient is when they first show up at the hospital or the day of the procedure. And so it's arguably impossible for those type of providers to comply with this disclosure requirement. Neonatology, again, they're called in after an emergency C-section or even a regular labor and delivery, and the baby needs, has a medical condition that requires their care. That's the first time they're going to see the baby is in the hospital when maybe they're performing a procedure or certainly providing any sort of services. Okay, so what must be in the disclosure? You have to inform the patient that the service may not be covered. Inform the patient they may be responsible for the cost. Inform the patient they have the right to request treatment by a participating provider. In addition, you have to provide a good faith estimate of the cost, and you must obtain a signature. You have to retain the disclosure for 7 years. So, almost every provider at this point is using electronic medical records. So you'll want to work with your vendor to have this become part of the medical record, because at that point, you'll have retention policies. And so this is just going to have to become part of the medical record to make sure you keep it long enough. Failure to obtain the signature or failure to provide the disclosure within the timeframes or in one of the situations that we just discussed results in a cap on charges. And that cap is, the same cap that we just heard, 150% of Medicare, or the carrier's median amount for the region and provider specialty. So obviously, it's going to be very important for providers to, perhaps be working, outside providers to be working with hospitals where they see patients, trying to coordinate the obtaining or providing these disclosures, promptly identifying out-of-network patients so that you can give them this disclosure and obtain a signature. The same is going to be true, particularly, like of surgeons, if you're an out-of-network surgeon, getting these at the time of scheduling, for example, a surgery, so that you meet that 14-day requirement. Disclosure difficulties. Again, I kind of already talked about this, but it's going to be nearly impossible. It's not very difficult for hospitalists, anesthesia providers, neonatologists, and other people who really just exclusively or primarily operate out of the hospital, and that's the first time they see patients. That 14-day requirement and that prohibition on providing this disclosure on the day of admission is going to be, or the day of a surgery, is going to be extremely problematic. Again, as I said, it's going to be important to identify out-of-network patients, to incorporate this new disclosure into your intake or scheduling documents, working with hospitals to help identify the self-insured plans, so that this won't apply to, or, in general, out-of-network plans, whether it's self-insured or not. You're just going to have to do this quickly so that you can come up with a way to get the necessary disclosure and get that signed without, within the confines of the law. All right, so there is a dispute resolution process. Oops, sorry. There's two different dispute mechanisms that are fairly narrow. There's one for disputing the calculation of a cap payment, right? So you talked about a median cap payment, or I guess it could also apply to the extent that it's 150% of Medicare. There's also a dispute mechanism for complicated cases where you think this median amount or the 150% of Medicare is insufficient and doesn't properly reimburse you given the complications of a case. And so there's a process for seeking additional payment in those situations. So for over cap payments, if you were paid 150% or the median amount and you disagree, you think, hey, median should actually be more, or I guess perhaps if someone pays you less than 150% of Medicare, claiming that that's the median amount, you can request a Department of Insurance of Financial Services review. The law states, how that happens. My understanding is they've identified, I think, one person to handle all of these disputes. So it'll be interesting to see if that's enough. They make a decision, and that's the decision. There's no appeal process. and there's nothing you can do if you disagree. Part of the reason for that is that, the DIFS is going to be provided data by the health plans that allow the DIFS to calculate what the median amount is. And so they will be able to review that information, determine whether 150 is higher or the median is higher than what was paid. And then they will, make a ruling based on that information. And for obvious reasons, payers, health plans don't want providers to have access to what all those median amounts are. So, there's not really going to be any way for providers to dispute or argue about these cap payments. There's no process. This is not the process for addressing denials and coding disputes, et cetera. Obviously, providers, things are down coded, things are denied as unnecessary, and this is not the process by which you would use to argue about those things. This is very much limited to you were paid and you think it should be median is higher, or you think 150 should be the payment. There's other dispute mechanism is the dispute involving complicated cases. The first step for that is to request a review by the plan. So it's similar to kind of a denial appeal. You send clinical documentation to the plan saying, hey, this is a complicated case. We're entitled to more than that median amount or more than 150% of Medicare. The carrier has 30 days to make an additional payment or deny the payment. And then the payment would be, if they decide that they are supposed to make a payment, that this was a complicated case, the payment would be an additional 25% of that median payment or 150% of Medicare. So that's the first step. Say you're still not happy or they deny it, they don't pay that additional 25%, you can request binding arbitration. You submit that request to the department along with your prior request to the plan. So as we often see in the reimbursement auditing world, you got to you have to provide all the right clinical documentation when you first dispute this with the plan. You're not supposed to be adding additional information by the time you get to arbitration. So you want to make sure you do it right the first time when arguing with the plan. You also have to provide the department with the plan contact information along with the denial letter. The plan has 30 days to either confirm the denial or propose a payment, or I suppose they can change their mind and pay the 25%. The parties get to, assuming they don't, settle the matter as a result of this request for arbitration, the parties then choose an arbitrator who issues a written decision in 45 days. My reading of the statute is, you're not going to be calling in witnesses and making experts and that sort of thing. So again, at that initial dispute with the plan, you should think about including some sort of narrative along with the clinical care in support of why you're entitled to these additional amounts. So, if you start adding together these different timelines, it can take 105 days before you would be entitled to be able to get a ruling on whether or not you're entitled to a higher payment because of it being a complicated case. And, one of the questions that I've received from clients relates to, okay, well, what do we do if if they down code or they remove an item, either it's medically unnecessary or they pay less for a given item than what our itemized claim charges them. And again, I think at least initially I would attempt to resolve this sort of outside of this arbitration. Again, I don't think these two dispute mechanisms are where you dispute denials or disputes about coding per se. These really are more within kind of the confines of the surprise billing law. That said, if the insurer says, hey, we're not going to go through this, your only way of getting additional money or disputing this is through arbitration, then I would encourage clients to say, okay, if that's what you're telling us to do, then we'll pursue this argument via arbitration. But again, I think this is something we'll see how these disputes play out. I don't have certainty as to what position the plans are going to take on some of those issues.
Well, and Tim,
all right.
Before we kind of move on, I guess I want to point out, and maybe this is a good segue, is that Nothing in this law is going to overwrite, the current kind of claim and appeal process that exists under, health plans today, right? So, obviously those claim and appeal process belong to the enrollee or the participant in the plan, not the provider. But I think you and I both know that, in the majority, it's not actually the individual that's pursuing the claim and appeal. They assign that claim and appeal, to the provider. The provider, pursues that on their behalf. So, again, to the extent that a participant will assign you their right, to pursue an appeal under the plan, that may be another avenue to, contest some of these disputes as well.
That's right, Tripp. Like as you say, and as people who are listening are familiar. People, if I'm enrolled in a plan, I have appeal and dispute rights, and usually paperwork when you when you get treatment assigns that right to the provider. So yeah, that's why I say I think that's the mechanism where you're going to pursue kind of the typical denials and down codes and disputes over, for certain fees. That's where you'll continue to see that. And there is a provision within the law that says, for being inexact here, it says nothing prevents plans and non-participating providers from sitting down and hammering out some sort of agreement as to how much they'll be entitled.
Hey, now you're getting into my territory.
All right.
So you can go to the next slide. So obviously, this is Tripp VanderWal, and I'm a member in Miller Johnson's Employee Benefits Group. So I'm going to be talking this more from the health plan. And I guess, just a couple, before I dive in kind of the nitty gritty here, and my area is not as complex as Tim's, and it's actually just kind of the other side of the puzzle here. Since this really only applies to fully insured plans, the onus of complying with this is not going to be on, in the group health plan context, is going to be on the insurer, not the plan sponsor. But, just how we're seeing right now on the self-funded side, now that the No Fault Reform Act is kind of into full swing, employers are getting a lot of questions about whether I can, opt out of, PIP under my coverage. So, a lot of those questions are funneling towards, HR departments and the like. As this law gains some notoriety, I guess, and people figure out, hey, providers are not going to be able to balance bill me, just like the No Fault Reform Act. I think there's going to be a lot of confusion about when this law doesn't and doesn't apply. So to the extent that, a participant, in a group health plan may get balanced billed, and even if that balanced bill is permissible, they may be showing up in an HR person's office saying, explain this to me. I understand that this can't happen anymore. And, so you may still see these issues, creep up here and there. With that, I've kind of divided my slides into the same that Tim did, and really, if you think about this, if you could obviously the legislature could have gone at this by just basically saying, hey, providers, unless you provide a notice, you can't balance bill. But I guess the idea is the other side of the coin on this is that in those situations, we at least have to have a minimum payment requirement to the provider. And so the minimum payment is basically for the required payment for the plan or the payer is going to be basically the same as what the amounts were capped at. So, starting with an emergency care patient, a health plan is required to pay within 60 days of receiving the claim from the non-participating provider, the greater of the median amount for the region and specialty, or 150% of Medicare fee-for-service schedule. And again, that only applies, which these are just kind of reiterations of what Tim said. It's provided to an emergency patient. It's covered by the patient's health benefit plan. It's provided to the patient by a non-participating provider at a participating or non-participating facility. But here's the key: in order for this to trigger, the payment amount on the plan side, the non-participating provider needs to submit the claim within 60 days of the date the healthcare service was provided. Next slide, please, Tim. Again, from a non-emergency care, so for in that setting, the health plan must pay, and again, there's that 60-day requirement for them to pay the greater of the median amount for the region and specialty, or 150% of Medicare. If the healthcare service is provided to a non-emergency patient, it's covered by the patient's health plan, and it's provided by a non-participating provider, but only at a participating facility. And then either if one of the following factors apply, and Tim discussed these, is either you don't provide the disclosure, or even if you do provide the disclosure, the patient didn't have the ability to choose a participating provider. And again, in order for this to trigger kind of the minimum payment amount by the plan, the non-participating provider needs to submit the claim within 60 days of the healthcare service. Next slide, please, Tim. And kind of the third situation that Tim talked about is, of course, receiving healthcare services within 72 hours after receiving care in an emergency room. A health plan, again, required to pay within that 60-day time limit, the greater the median amount for the region or specialty, and 150% or 150% of Medicare, if the healthcare service is provided by a non-participating provider at a hospital within 72 hours after receiving a healthcare service at the hospital's emergency room. Now, what is interesting about this, and Tim and I have kind of gone back and forth about this, is if you look at the way that the language in the statute is listed for this 72-hour situation, the requirement says basically it applies to any healthcare service provided to the emergency patient during the hospital stay within that 72-hour period. It does not have the the limitation that it's covered by the patient's health plan. So I guess the question here, Tim, is if I go get if I end up in an emergency room and I'm admitted to the hospital, if I receive a service within that 72 hours, which is either specifically excluded by my health plan, or maybe excluded because it's determined to be not medically necessary, does the plan have to pay for that? And I think if you would actually read the language of the statute, would say yes, but I have a hard time just convincing myself that a law could interfere with a contract like that. I don't know if you have any thoughts on that one.
Yeah, I mean, I agree that sort of the plain language of the statute elsewhere, it talks about only for covered health services, right? Health services that are covered by the plan, and that language is not in this 72-hour provision. So, there's obviously an argument, but I agree that I don't think that was the legislature's intent, was to somehow expand liability to health plans. I mean, it seems unlikely to me that you're going to encounter a situation where there's excluded services provided. But again, does it arguably remove the plan's ability to argue about medical necessity, right? Medical necessity would not be covered if something is medically unnecessary and the plan takes that position. That would be not covered. It would not be a non-covered healthcare service. So can they not make that argument now? The plain language, I think there's an argument that's true, that they can't make that argument. But again, I agree with you, Tripp, that wasn't the intent.
That would be interesting because, I mean, from a plan side, my experience is, plans are never going to give the medical necessary determination, at least with respect to payment, not necessarily with respect to, what service are actually provided. But plans are never going to turn over that, medical necessity decision to the provider. Right. It almost seems like, a conflict against their own interests. But, this is actually maybe before we are going to move into here some questions, but that we've actually kind of pre-thought of. But there is a question that we got through the chat feature about services covered by the plan, and what about services that are not covered by the plan? And that brings up kind of an interesting conundrum. So if you look at the way that these statutes were drafted, and I apologize for referencing the numbers, but I don't have any better way to do that. But section 24507, from a general perspective, addresses the plan payment requirements, which I've just addressed, and says, when these situations apply, the plan has to pay these minimum amounts. On the other side, section 24509 addresses the disclosure requirements, so when the disclosure has to be provided and what the disclosure has to contain. The section that addresses the plan provisions talks, except for the 72-hour exceptions, talks very clearly about, the services have to be covered by the plan. But 2409, which addresses the disclosure requirement, basically applies to any healthcare service. The problem is, though, Tim, is if you, upon a closer reading of the provision that applies to the disclosure, it says a non-emergency patient's carrier shall pay the amount described, above, which is either the 150% or the median amount, within 60 days. So again, I think, in a situation where an individual fails to provide the notice and the provider is subject to the cap, it seems to be that if you, again, the pure language of that statute appears to start saying plans have to start paying for any healthcare services, rather whether they're covered or not. So I think we're going to need some additional guidance on that from diffs, or potentially Laura, right? Because all of these statutes generally fall under the public health code, not the insurance code, which is another interesting thing.
Yeah, that's a good point. Yeah, I think from the provider's perspective, you submit that claim, you provide the disclosure, the plan claims it's not covered and won't pay you the money. As long as you provided the disclosure, you can balance bill the patient. And then at that point, if the patient wants to argue with the plan that it should be covered, then, you're kind of out of that dispute. But there would be nothing in that situation to prohibit you from billing the patient for that, which, I guess gives you a little bit of help in getting payment.
But yeah, but to kind of build on your example, I'm a provider and I don't provide the notice, which means I would be expecting to get one of the capped amounts, but the plan says it's excluded. Can the provider come back and say, well, section 24509, which basically dictates me to provide disclosure, which I failed to say, still says that the patient's carrier must pay this amount. Again, the plain reading of the law would say, yeah, you could make that argument. I can't believe that. Seems like
right. Yeah, I think
interference with private contract.
Yeah, I think we're going to see some litigation on this bill.
Well, with that, we'll keep moving along. Next slide, please. So as Tim kind of mentioned, again, nothing in this law basically prohibits a plan and a non-participating provider, from sitting down in some setting, whether it's private negotiations or an internal dispute process, and agreeing to a different or a greater, amount than what's required under the statute, which would be either the greater of the median or the 150% of Medicare. And with that, I think we can move in, we'll move into our question period. And I think, starting off with some of the questions that we've identified. So I'll kick it back over to you, Tim.
Yeah, so, this first one I kind of addressed on, I've mentioned it a couple different times. There's providers that only see patients in hospitals. Again, these are going to be relatively rare circumstances where the facility is participating and the provider is not participating. But, how do you obtain these disclosures if a plan decides that it's beneficial for them to only have to pay out these median amounts, and they say, well, we're not going to contract with these outside providers anymore. How do they comply with these disclosure arguments or these disclosure requirements? And again, I think it's not clear to me how you do that, unfortunately, because of the 14-day requirement and the prohibition on doing this on the day of admission. So, if people have creative solutions or they want to put their heads together, please give me a call and I'm happy to try to come up with some solutions for this. Again, what about our more typical denials and reimbursements, downquoting? Again, I think as Tripp and I both have mentioned, you'll be disputing those kind of through the current process where, you've been assigned the patient's right to payments, and you can use that internal dispute resolution. If an insurer takes a position that you can't do that anymore because of this bill, then I guess you have to go through that second arbitration procedure. But again, I don't know how insurers will do that, but my opinion is that it would be through kind of like the typical denial that we're used to. How do you counter insurers' newfound leverage? Again, they have sort of a maximum rate for non-participating providers. Again, I think here is saying, hey, we can comply with these disclosure requirements. We put a policy and a procedure in place where we're going to get these to patients, non-participating patients, and we'll get them to sign these and, kind of act unperturbed by this law. Or the other option is, consider legal challenges. To the extent that this is impossible for providers to comply with, there might be some legal remedies through litigation, and trying to invalidate certain portions and provisions of this law would be something that providers should consider as well. What happens if non-participating provider doesn't submit claim to plan within 60 days?
Yeah, so this is a good question that I don't think we have an answer to, but if you look again at the statutory text, at the provisions, the plan payment provisions in 24507, one of the requirements for this to apply is the provider submits the claim within 60 days. And if you don't, does that mean the plan can pay less than that? And arguably, I think it does. And I think this is further complicated is what if you submit what the plan decides to be, an insufficient claim, right? Like, they don't have enough information. Does that, you have to actually have a full, complete claim, a clean claim within 60 days. Is there any extension of those times? And again, under the statute, there's no guidance on that. So, kind of building on that example, if I don't submit the claim within 60 days and the plan pays me less than the statutory required amount, can I, as a non-participating provider, balance bill the patient, not all the way up to my listed charge, but to the greater of what I would have expected, the statutory amount? And again, I think, the answer to that would be no, Tim, because if you look again at the statute's language where it talks about not only does the provider have to accept the capped amount as their total fee, it says the non-participating provider shall not collect or attempt to collect from the non-emergency patient any amount other than the applicable in-network co-insurance, co-payment, or deductible. So in those situations where you get the claim in after 60 days and you get an amount that may be less than the statutory amount, I think you're stuck with that. Again, outside of the typical in-network participant cost sharing amounts.
I agree. I agree with you, Tripp. I think they said 60 days for a reason. Certainly plans, I suspect, will take that position that, it sort of acts as a bar on them having to make payment, or at least having to make the payment required in the amount that's required by the statute. And I don't see how you're permitted to bill the patient for those amounts because you didn't do it within 60 days. As you and I discussed offline, the intent of this is to sort of keep patients out of these disputes and to prevent a patient from getting 60, 90, 120 days, some bill when they thought everything has been paid by their provider. So, I think there's a reason for that 60-day time limit. And if you miss it, I think it's likely there'll be consequences.
Exactly. And I think, on the plan side, remember there's that 60-day payment requirement, which I think, in a perfect world is not a problem, or in a majority of the cases not a problem. But, if you think about, is there enough, coordination of benefit issues, is there another payer that may be on the hook for some of this? It may be difficult to pay this amount, if you've got to work out some coordination of benefit issues.
That's a good point.
Moving on to the self-funded plans, again, self-funded plans, if you basically tell a self-funded plan you got to pay the minimum amount, self-funded ERISA plan, that is, excuse my term, but the self-funded plan can tell the provider to go pound sand. So again, I think, obviously if you provide the disclosure, you can generally balance bill the patient, and that would be included all the way up to your list charge. But if you don't provide the disclosure, and similarly the self-funded ERISA plan pays you less than the statutory amount, can you balance bill the patient up to that statutory required amount? And again, I would say based on the language of the statute, it would appear that no, you can't. The only thing you can get is what the plan pays you, and then of course the in-network participant cost sharing amount, co-payment, co-insurance, or deductible. well, the deductible wouldn't really apply, but co-insurance, co-payment. And then, of course, you still have those, like we said before, those appeal, if the extent the participant assigns you their appeal rights, maybe we can pursue it that way or through some other, dispute process.
Well, that brings us to the end of our presentation. And Tripp, I think there's a couple questions we did get offline, and I think some of them are a little complex to answer via a webinar, but I'm trying to recall what we're.
Yeah, it's 12:51, so maybe we spend a few more minutes and round it right out of an hour answering questions. So, I'll feed a couple of you that we've had. So if it says if payers are not approving, one question, if payers are not approving 100% or 150% of Medicare, nor applying that amount as patient responsibility, what steps do you recommend that we take? And again, I think you kind of answered that, but maybe to cover that, to round that one out one more time.
Yeah, I think we kind of, wait, say that one more time.
If payers are not approving 150% of Medicare nor applying that
right.
as a patient responsibility, what steps do you recommend that we take?
Yeah, well, if they're not, again, you can appeal to the department if you think that either 150 or median is the correct amount, but they're not paying, but they paid under that. So you would appeal that through through the department, the DFIS.
Here's an interesting question. And if payers just outright deny a service as not covered and do not list the charge as patient responsibility, what steps should we take then? And, I think if it's a not covered service, at least with respect to non-emergency care, I'm not sure that this law would apply, correct?
Right, I agree.
And therefore, the provider could balance bill. Now, in the emergency context, and I think we kind of talked about this briefly before we went live here, there may be very limited opportunities where a non-participating provider in an emergency context can balance bill, correct?
Right. Yeah, I think so. I think there'll be exceedingly rare circumstances, and I'm not sure that I can come up with a factual scenario where that might come up. But yes, I think, when the plan is taking the position that something is non-covered, I think you're frequently, if not always, you'll be able to balance bill the patient.
Then we've got two. This is two similar questions in the chat feature that came in. It basically says, what if we can't submit the claim within 60 days because we didn't get, insurance information, timely insurance information, because we may not have had, initial contact with the patient. So we didn't get it, insurance information necessary to know where to bill. What if that's the reason we missed the 60-day window? I don't think we have an answer for that based on the statute. The way you read the statute, it's 60 days, 60 days, 60 days. It doesn't give any exceptions to that.
Right. Yeah. I can think of situations where a patient comes into the ED. They've been in a car accident. They say, "Hey, I have no-fault insurance through, Farm Bureau or whatever." Well, it turns out that they didn't because it was canceled. They didn't make payments, or they committed fraud. You don't find out about that till well after 60 days. I would certainly encourage clients to build the health plan at that point, but it'll be interesting to see how, health plans, what position they take on that sort of factual scenario.
Well, and, you can dispute right through the DIPS process, the payment amount to the extent that you disagree that it wasn't up to the statutory required amount. And it seems like maybe in that situation that if the reason you didn't submit the claim, you submit the claim after 60 days, the plan pays you less than the statutory required amount, and you contest that, and the plan's defense is, well, they didn't submit the claim within 60 days. Maybe you bring to the table, here's the evidence to show that I couldn't, it was outside of my hands. Maybe that's an issue that's you could solve, through the DIFS dispute resolution process.
Yeah, I think that's a good point, Tripp. I think sort of my thought process for providers on these scenarios that don't clearly fall into one of those two dispute resolution buckets is that, you work with a plan if you're getting nothing from the plan, they just ignore you or continue to take a position that you think is unreasonable, there's nothing that stops you from, going to the department or choosing arbitration. And, maybe this evolves into something. At the very least, doing that would put you in a better position to then, bring a lawsuit against an insurer and say, and lay it all out and explain your theory as to why you should be entitled to payment. And, I think that's a compelling argument. It's not your fault that you couldn't get information from the patient, or you got the wrong information from the patient, which is something I've seen before as well. So I think there's, you want to pursue all those options. Again, I think first you go to the plan directly. If you're getting nowhere, then I think you look at one of those two dispute resolution processes.
And finally, two of the other questions we got, previous to the webinar, which I'll address, is questions relating to self-funded plans that I guess are outside of the state of Michigan, and whether that, what we do in those contexts. And again, I think the answer to that is very similar. Both is, again, this law, with respect to self-funded plans, this law only applies to self-funded plans sponsored by the state of Michigan or a government located in the state of Michigan. And so you may have a self-funded plan that have, out-of-state residents, for example, a retiree from a government that's still, participating in self-funded plan, but has moved from Florida and is back. But again, I don't think that in the context of self-funded plans, outside of those that are issued in Michigan because they're either sponsored by the state or a state government, this law is just not going to apply at all. But, keep in mind that the federal law is coming down the pike, and that is going to apply. And with that, Tim, I think we've gotten through all the questions. I don't see any more in the chat feature. So I don't know. I have nothing left to say. Thank you, everybody, for spending your lunch hour with us. Hopefully, you gathered some knowledge from this webinar. Again, even if it was only a brief Latin lesson. Tim, you have anything else to add?
No, I don't have anything else to add. Thanks. And obviously, if you have questions, please reach out to either myself or Tripp, and we'll do our best to answer.
All right. Thanks, everyone, and have a great weekend.
Thanks.